Breaking news, guys. The U.S. Securities and Exchange Commission in the XRP sales discovery request. SEC might end up victorious over Ripple. After defendant Ripple voiced opposition over 2 years worth of audited financial statements, post-complaint contracts to sell or transfer XRP to non-employee counterparties, and details about the amount of XRP institutional sales proceeds received after the lawsuit was prosecuted, the U.S. Securities and Exchange Commission submitted a response. According to a court filing that was delivered late on January 23rd, Ripple allegedly responded to the U.S. Securities and Exchange Commission by providing new evidence in support of its petition to compel. According to the plaintiff's SEC, its requests for information regarding potential remedies are not premature, but rather within the bounds of proper procedure. Furthermore, it argues that while deciding on remedies for breaches of securities law rules, courts mainly consider events that have occurred after the complaint. Additionally, the Securities and Exchange Commission is making an effort to convey a similarly forceful message. This organization is not seeking a mini trial or any other decision about the legality of post-complaint sales to entities, including ODL customers, only that Ripple be penalized for infringement of securities laws. It argues that it need not do so in order to get an injunction that would stop those transactions in their tracks. Picture, Ripple wants to avoid having future ODL transactions categorized as institutional sales, which are subject to the summary decision. It can say that it has plans to structure them differently. But the SEC says it should be the one to have the post-sale and post-summary judgment contract to look into Ripple's plans and see if they can legally conduct a DL sales. According to Bill Morgan, an attorney who is in favor of XRP development, there is a lot riding on this issue, even if it doesn't result in a small trial. The online decentralized ledger company of Ripple might take a hit from a wide injunction. It is my expectation that these contracts entered into after the complaint will be the subject of a discovery order. The response from Ripple to the SEC has been received. In discovery, SEC has requested financial statements. Caroline DeSherry's statement on behalf of Ripple states that the SEC did not seek discovery while the fact discovery was continuing, thereby ruling out any need for additional information regarding sales made after the complaint was filed. Furthermore, the SEC has used all of its interrogatories related to this specific case. After the SEC requested it, Caroline DeSherry, who was a consultant for Ripple from 2015 to 2019, made a public statement. According to her testimony, Ripple's various business records show that between July 2017 and April 2020, 23 separate counterparties entered into XRP direct sales contracts with Ripple through XRP. She went on to say that most XRP sales between May 2020 and June 2023 were transactions, meaning that Ripple was the source of the XRP. She went on to say that Ripple has sold XRP to unidentified buyers via market makers on centralized digital asset exchanges. As part of the ongoing litigation involving XRP, Ripple Labs and the U.S. Securities and Exchange Commission have submitted a detailed response to the Sarah Netburn in the Southern District, who serves as the United States Magistrate Judge. With the release of this document titled Reply in further support of its motion to compel, the SEC has taken its pursuit of full discovery from Ripple to a key new level. In response to Ripple's claim about the scope of discovery, it emphasizes the dynamic character of the lawsuit and cites particular court records to show that lengthy discovery periods were considered and eventually approved. Additional discovery periods are also being considered, which is highlighted. An XRP supporting lawyer named Detton explains why Ethereum got away with so much. Additional reading as soon as Judge Torres gave his approval to this method. According to the SEC, the action has been defined by an iterative and adaptive discovery process, which has been cited in court documents. The securities dispute centers on the relevance of Ripple's financial status and its institutional sales contracts following the complaint. Alteration Commission contends using precedent, the Securities and Exchange Commission successfully bolsters its position. To highlight the importance of a defendant's wealth in determining fines, it specifically mentions the case as SEC while determining the appropriate level of punishment to discourage wrongdoing. The Second Circuit specifically rejected this argument according to the Securities and Exchange Commission's answer. Consideration should be given to the defendant's riches. As the SEC story unravels the meaning of Ripple's post-complaint institutional sales contracts, it draws attention to the paper's strategic significance while also illuminating Ripple's intentions about the sale of XRP. The SEC views these contracts as both historical records and potential indicators of future regulatory infractions, suggesting that they may have been overlooked in the past. The Securities and Exchange Commission statement states that it is anticipated that U.S. banks will use XRP for overseas payments. It was mentioned that the specific contracts that the SEC is looking for after compliance serve as proof of this claim. This statement seemed to suggest that these records might show patterns or intentions that could affect whether or not the parties comply with the court's orders in the future. SEC investigator and fundamental business attorney for Ripple has spoken out in support of XRP and offered his views on the alluring strategic posture via his client. He claims that the Securities and Exchange Commission must prove to the court that, contrary to Ripple's claims, requesting the discovery of contracts entered into after the complaint has been filed will not lead to a mini trial concerning the standing of sales entered into after the contract. The Securities and Exchange Commission, one of the two institutions represented by, has declared that it is not pursuing a mini trial or any other kind of decision with respect to the legitimacy of sales made after a complaint has been filed. Morgan notes that the business maintains its position that it is not required to do so in order to defeat the injunction that would stop the transactions in question. The lawyer also thinks Ripple would try to get out of the summary judgment institutional sales category by claiming it plans to restructure future XRP sales, which were previously old sale in a certain way. Because of this, Morgan believes these data will not lead to a mini trial. A lot is riding on this issue, though. The online decentralized ledger company of Ripple might take a hit from a wide injunction. On these contracts that were entered into after the complaint was filed, I anticipate that the court will issue a discovery order. 4 more Bitfavo wallet addresses sent 25 million XRP in 4 separate transactions to various recipients at varying intervals shortly after this first transaction. With these 5 transactions, the total amount of XRP exchanged reached 125 million, which is now valued at $64.3 million. Curiously, 4 of the XRP whale addresses that have been investigated by the Crypto Basic are also fresh wallets that were activated today. One of them, nevertheless, has a December 8, 2023 activation date. Even though it had been there for more than a month, this address had remained dormant until the most recent transfer. It is worth noting that prior to sending out the 25 million XRP, each of the sending addresses got millions of XRP, ranging from 198 million to more than 223 million tokens from unidentified sources. This trend indicates that the culprit may have utilized the sending addresses to reroute the monies. Worth noting is that market participants leaped to conclusions about whether Ripple is causing such massive whale moves. So that's all for now.